Just press the Let's Go Live button. So we are waiting for the stream to fire up all across the fruited plains of the internet. If you're not familiar with the show, we do multi-stream. Facebook is usually pretty fast to get us online, but sometimes YouTube takes a second. But it looks like we're there, so let's get started. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our criminal justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice, and it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of encouraging some meaningful change. And you may notice we're a little bit early today. It's going to be a little bit of a condensed show. We still have a lot to get to, but I've got to get out of here pretty hard at about an hour and a half from now. So we're going to get to some questions at the end of the presentation. All of those are going to be available over on locals.com. So head on over there if you want to send some questions in, but just be forewarned, if we are sort of running along, we may not be able to get to that many questions today. So I apologize in advance. Now, we do have a lot to get to. Yesterday, Joe Biden had a town hall and some criminal justice issues came up. And so we've got a couple of clips. We want to run through that because if you've been a part of this channel for some period of time, you know that I have not been a particular fan, myself being a criminal defense attorney, of Joe Biden and his crime policies over the last 30 years or so. So it's nice to hear what he has to say now that he's the president. What are his new policies going to be? He gave us some insight on that. So we're going to go through that. We're going to look at a little bit of what his record looks like, just as a reminder, because we covered a lot of this stuff before the election took place, but largely I think it has been ignored by the media. So we want to just sort of run you through what this new administration is doing and make sure that we're reviewing it in context of what all the other things Joe Biden has done over the years. Then we're going to talk a little bit about the guy called John Earl Sullivan. We've already spoken about him. He was one of the BLM, Antifa-ish people. I think all of the groups are disavowing everybody now, so it's kind of hard to find where he had a home. But John Earl Sullivan was somebody who was in the Capitol Hill building, in the Capitol Hill congressional building on January 6th. And we just learned that some of the major media companies around our country paid him a lot of money for his footage. And so that's a little bit of a scandal. We're going to go through that. Then we're going to talk about some updates as it relates to case law. So we have two Circuit Court of Opinions, one shared by our one of our favorite viewers, Mr. Chris Wiseman, gave us a plug over on Locals and alerted us to this story, qualified immunity case out of the Fifth Circuit about a guy who was covered in gasoline. Court basically said, that's all right. You could have tasted him anyway. So I want to go through that opinion, no ridiculous one. Then we have another good opinion that came out of a federal court in New York, basically saying that the New York Police Department can't bargain away their right to disclose, or the duty to disclose information about police misconduct. So good news on that front. But before we get into any of it, we have to just pause and pay tribute to an icon. Of course, I'm talking about Rush Limbaugh. Rush Limbaugh is no longer with us today. He passed away after a long bout of lung cancer, born 1951, passed away 2021. This was a picture of him when he was receiving the Presidential Medal of Honor, I believe it was, back at the last State of the Union. And, you know, this is a pretty big deal. And I wanted to just share a little bit about my thoughts on it. When I was a boy, I grew up listening to Rush Limbaugh, and a lot of people have a lot of opinions about the man. I think a lot of those opinions are largely sort of filtered. You know, they've got an opinion of him because of other things they've heard him say. And I think that, you know, if you actually listen to the guy for a long period of time, whether you agree with his policies or not, you'll understand he was very witty. He had alternative viewpoints, alternative interpretations for a lot of the events going on around the world, had a lot of interpretive analytical interpretations of what was going on in the political world and America in general. And, you know, as a boy, it was something that I didn't really understand, but I listened to a lot. It was, you know, my mom used to listen to him when we would get into the van for soccer practice, and the volume would be very high, and I would be 6, 7, 8 years old, and I'd be like, what the heck is she listening to? Who is this guy screaming on the radio about stuff I don't even understand or have any interest in? But I would listen to him enough, and there were a lot of things that I could even understand at that young age. The sort of the cadence of his voice, a lot of the anger and frustration, the emotion that he conveyed through the radio to the other side, to people listening. And then I just slowly started to listen more and more. And then as a boy, I would sort of listen without my mom. I would just sit in front of the radio and listen to this guy, even though I didn't really know what he was talking about. I didn't know the structure of the government. I didn't know who these senators and Congress people were, but I would still listen to him. And, we didn't have much growing up, and it was sort of one of those things that we would do. Many families would get up and watch Saturday morning cartoons, or they would, go on a walk with their dog or something. We would just kind of turn the radio on and listen to Rush Limbaugh. And eventually in my life, that sort of stuck with me. And so when I went to college, I was still cleaning pools before I went to law school. I was building pools, cleaning pools before I started to build them. And when I would be cleaning pools in 115 degree weather all throughout Arizona, I would have, back in the days before we had these nice cell phones, you'd have those little armbands that you would wear on your arm as you're doing things. You wear it at the gym, but it was a radio. It was like this big, an FM, AM radio that I would just plaster on my arm, and I would just put Rush in and listen to him. I think it was from like 12 to 3 here in Arizona for 4 days and for months and for years. And, I learned a lot, and I thought that it was one of the first times in my life where I sort of developed a relationship with somebody on the other side of the microphone. And it really inspired me in a lot of ways to do what I'm doing today. And so I just wanted to pay reverence to him for being somebody who has helped motivate other people to be a little bit more expressive. When I was in college, I decided, hey, you know what, maybe I'm going to go try and broadcast a little bit. My first major was journalism, and I thought I was going to go into that field until I had to start dealing with the people in that field. And I thought, this is not going to be a good fit. Then I sort of pivoted and went into political science before going to law school. But my first 2 years at ASU, Arizona State University, I actually tried to go and broadcast at a radio studio there. There's a little station there that I think just covers campus called The Blaze. I think there's 1060, 1260 when I was there. And I would go there. I'd get up at 7 in the morning and go do the morning show on Saturday mornings. All of my friends would be hungover. I would be hungover as well, but I'd still go down there and I would broadcast for a certain period of time. And I thought, this is sort of that was kind of the birth moment of me wanting to get into some broadcasting and maybe, start doing some media and stuff. And then it just kind of disappeared. I went to law school, and they beat any sort of creative expression out of you. They say, every word that you say can be used against you. Every period, if it's in the wrong spot, you're going to get scolded and disbarred, and they're going to throw you in prison. In fact, if you anger a judge, you're going to go to jail forever for your whole life. And so all of that creative sort of, ability to go out there and be a little bit provocative, express your ideas to the world, that was sort of really bottled up for me for a long period of time. But here we are. And I would still listen to Rush. There would be times when I would kind of go on these Rush waves where I would listen to him, and then I'd kind of, move on to a different commentator for some time and kind of get tired of him and then come back to him. But this last little bit of his life was something, I can't believe he's not here with us today. I mean, honestly, the headline sort of hit me in the gut. It made my stomach fall quite a bit. And I just thought we were going to have a little bit more time with him, and we were going to have a little bit more of his commentary, but he has moved on. So I just wanted to start off with that. I know a lot of, he's a fiery figure. A lot of people, I think, misunderstand him, but I think his heart was in the right place. I think he wanted to help people. I've always found him to be very grateful, very gracious. He was, a big personality for sure, but somebody who I thought was moving forward in the right direction, at least talking about ideas that I think were helpful for the country. So while there's a lot of vitriol being spread around the internet right now, just a massive amount. I was on Twitter, and it just makes me sick how much people get glee out of the passing of another person. I mean, I think if there should be dignity anywhere in life, it should be in death. And some of the comments that I've been seeing on Twitter are just horrendous. And I just can't imagine myself ever feeling like that about anybody on the other side of the aisle who disagrees with me politically, whatever it is. You just have to have, I think, a little bit of respect and reverence for all people who transition into the next life, because we're all going to be there as well. And you don't want to be speaking about in that way. And so, I know I'm spending a little bit of time on this, but I think it is important just to mark this moment down. And I want to thank Rush Limbaugh, say my prayers for his family and for the rest of America who is grieving his loss, because I know that I certainly am. I will never forget Rush Limbaugh. Rest in peace, my friend. We will connect later in the afterlife. All right. So now let's get into the stories. Let's get into the news. As I mentioned, Joe Biden had a town hall conference yesterday, and there was a lot of reaction to it. There were clips flying around. Joe Biden was talking about China and President Xi Jinping and the Uyghurs and all sorts of big, broad issues that have been catching a lot of traction on Twitter. And so we thought, well, we're going to ignore some of those main clips. They're interesting, they're provocative, they're concerning, but let's focus on what he talked about as it relates to criminal justice reform. We've been talking about this a lot. This is kind of the crux of the channel, right? Watching the watchers. I'm a criminal defense lawyer. We have a decent sized criminal defense firm here in Scottsdale, Arizona. And we deal with these issues very regularly. And so I was excited to see that there were going to be questions about justice reform. You recall that in 2020, we had months of summer unrest. It's still going on in some parts of the country. We had the George Floyd death. We had Ahmaud Arbery. We had Breonna Taylor. We had Jacob Blake. We had Daniel Prude. And we've covered all of those and more on this channel. And so this has been an issue that's been at the forefront of my mind. But when we heard from Joe Biden yesterday, it didn't really match what I knew of the candidate, what I knew of Joe Biden, because I certainly have been following him for some period of time, because he, as I've said on this channel, he is the godfather of our current criminal justice system. And so I want to explain what this looks like. Before we get into some of the clips, let's lay some context here, because he got a lot of applause last night, and I just don't think that many people know the full breadth of his impact on the justice system. So this story came from the New York Times, and you'll notice this was written back on June 25th, 2019 by Cheryl Gay Stolberg and Astrid Herndon. And, when you see stories like this that are sort of critical about somebody who is now in power, I think it's important to take a look back at the timeline, right? So this would have been really sort of in the early primary stage when Joe Biden was just starting to run for the presidency this time. And so you're going to see a lot of these stories that are actually sort of calling him out on his past record. But anything that is new is sort of being whitewashed. And I even went on to Wikipedia here to look at some of his record as they have it there. And they just kind of got rid of his name from a lot of the crime bills. The 1984 crime bill, 1986, I think I saw, but I was just poking around and I didn't see much of it. But the good news is we covered a lot of this previously before the election. And so we're going to be able to revisit some of our prior research. So I wanted to just call your attention to that. So in 2019, it was okay to criticize and condemn Joe Biden for his record, but now not so much, right? Now that he is the official de facto, he's the president, he's the leader of the Democratic Party. Now, all of the little, newspapers and websites and Wikipedia editors, now they're making sure that he's nice and fortified and protected. But this article came back in 2019. Before that was the modus operandi. And so it says here, Joe Biden said, lock the SOBs up. Joe Biden in the era of mass incarceration. He now plays down his role overhauling crime laws with segregationist senators in the 80s and 90s. That portrayal today is at odds with his actions and rhetoric back then. In September 94, President Clinton signed the new Violent Crime Control and Law Enforcement Act, known as the 1994 Crime Bill, in an elaborately choreographed ceremony on the South Lawn of the White House. Joe Biden sat directly behind the president's lectern, flashing his trademark grin. For Mr. Clinton, the law was an immediate follow-through on his campaign promise to focus more on federal attention on crime prevention. But for Biden, the moment was the culmination of his decades-long effort to closely marry the Democratic Party and law enforcement and to transform the country's criminal justice system. In the process, he had won. And he said, the truth is, Mr. Biden had boasted a year earlier in a speech on the Senate floor, every major crime bill since 1976 that's come out of this Congress, every minor crime bill has had the name of the Democratic senator from the state of Delaware, Joe Biden. And that's his own statement, right? And that is exactly right. That's exactly true, which is why I call him the godfather of mass incarceration. He's the godfather of the modern American judicial system, the justice system as we see and know it today, the one that I'm practicing in. We've got several different attorneys here, all practicing in it. We got a whole team of people. It's the byproduct of what Joe and his people did back in the 70s, 80s, and 90s. And so we got to just remember that. So in my humble opinion, sort of a come to Jesus moment, sort of a, whoa, we kind of screwed that up, mea culpa. We got to view that in context. I'm happy that he is now coming to the light. Happy now that he's seeing the error of his ways. But the question is, now that he's the president of this country and he has the House of Representatives and the Congress in terms of the Senate, is he going to do anything to actually unring this bell? Is he going to unwind the clock a little bit so that we can solve these issues? Or are we going to hear just more bloviating from the Democratic Party, just like we hear from the Republican Party? So let's go through Joe Biden's record just briefly. We've talked about this before on the channel. If you doubt my sources on any of this stuff, you can go look it up, download these slides. You can find them. This information comes from Vox.com, from Slate.com, News and Politics from 2015, 2019, Joe Biden, the crime bill law, mass incarceration, why the presidential run's a bad idea. All of this stuff came from before he was the nominee and, of course, the president. So go back and find those articles if you want. But Joe Biden was elected to the Senate in 1972. Then in 1984, he was the original co-sponsor of the Comprehensive Control Act. Okay, 1984, 1 year before 1985, the year I was born. Joe Biden then on 1986 was also the original co-sponsor and the co-author of the Anti-Drug Abuse Act of 1986. And we're going to hear about drugs because Joe Biden was talking about it last night. Then a couple years later, that wasn't good enough. So they needed another one in 1988, where Joe Biden was once again a co-sponsor, the Anti-Drug Abuse Act of 1988. And we're going to go through, I'm going to briefly bring you up to speed on what each one of these acts are. Then in 1994, this was the big one. This was the 1994 crime bill that he's gotten a lot of grief over. Haven't paid much attention to his other bills, but 1994 in conjunction with all the 84, the 86, the 88 bill are all bad. And the 1994 Violent Crime Control and Law Enforcement Act, Joe Biden was the sponsor and the author of the bill. And after this point in time, after that all came into effect, this was one of his, he would tout this point all the time. He would say, yeah, we solve crime. And what we're going to do now is just transition. We're going to listen to Joe Biden at the town hall last night. You're going to see that a public defender asks him a question, and pay attention to the question and then pay attention to the response that we're going to get from Joe Biden. He gives us a 3-point solution. This young man who's a public defender comes up, asks him a question. What are we going to do about this? And he gives us 3 points. So pay attention. We're going to break those down. This is a longer-ish clip. I think it's about 4 minutes. I do not want to take him out of context. I do not want people to be saying that we're doing like a gotcha show here. I was going to clip this up into 30 seconds and 60 seconds and just point response, but we're not going to do that. We're just going to let him go for 4 minutes, flesh out his whole policy proposal, then we'll critique it in the next segment. So here is Joe Biden over from last night.
If I say anything you don't like, let me know right away, will you?
All right, you're all right.
As big as a mountain.
Good evening, President Biden. I was a public defender in Kenosha County when the police shot Jacob Blake. I witnessed the city I worked in burned and devastated, and recently District Attorney Michael Gravely denied to prosecute the police officers responsible. So my question to you is, what will your administration do to correct these wrongs that we witnessed not just in Kenosha, but across this country? And what will we do to bridge the gap between communities and their police?
3 things. First of all, I was a public defender as well. And I think it's high time that we had public defenders being paid the same as prosecutors.
That's one.
My son, by the way, was a great prosecutor. He was the Attorney General of the state of Delaware, and he was a federal prosecutor before that. And so I'm not condemning all prosecutors, but I am saying that it matters that you have adequate defense and you are able to attract people who, in fact, can live on being able to be that public defender. Number one. Number two, we are pushing very hard, and I think we'll get it done, is the legislation relating to what is appropriate police behavior and studying police behavior and coming down with recommendations that are consistent with the legislation that was put in place as a consequence of all the world seeing one man shoved up against a curb and murdered after 8 minutes and 46 seconds. And so there's a number of things relating to everything from no-knock warrants and a whole range of things you know. There's legislation that's being introduced separately. I hope it will pass. But thirdly, I think we have to deal with systemic racism that exists throughout society. And one of the things I'm going to recommend there is that we look at an entire panoply of things that affect whether or not people of color primarily are treated differently. And that goes for everything from prosecutorial discretion. You know, as a public defender, and by that I mean, what happens is, it would take too long to go through the whole explanation, but let me try to do it quickly. What happens now is, if you in fact are you arrest someone because they had, you want to charge them, you can charge them with robbery or armed robbery. You charge them with armed robbery, you get a lot more time than if you don't charge with robbery. But if you want to make sure that someone who doesn't know much about their representation is able to be done, you engage in prosecutorial misconduct by offering them to plead to essentially, it's not the same, burglary, which gets them 2 years and probation. And so you don't even get a trial. You plead because you don't have adequate representation. You feel like everything's against you, and you're in trouble. When I did the Sentencing Act, that was designed to make sure we had the same time for the same crime. As chairman of the Judiciary Committee, I looked at all 10 federal districts, and we took 6 months to do it, and found out if you're black and you were your first time offense of being accused of burglary, and maybe you committed it, and you were white, and you did the same exact crime. In all 10 districts throughout the United States of America, the person, and don't hold me the exact numbers, but the percentages are right. If you were a first-time white guy, you'd get 2 years. You get 7 years if you were black. So in order to make sure that you could not send people to jail for the same crime, I came up with this sentencing commission, which said that everybody who commits the crime has to receive between, instead of 0 to 20 years, you drastically cut down the number of years you could go to jail, but say you have to, if it's a first-time offense, you have to get sentenced between 1.5 and 3 years, okay? Well, what happens is prosecutors use that as a mechanism to send people to jail, and makes it look like we're dealing with mandatory sentencing, which it wasn't designed to do at all. It was designed to make sure that people were treated fairly. I'm sorry to go on. There's much more to talk about, but
we actually have a...
All right, so let me go ahead and translate that for you if you had trouble following him along. Number one, first of all, well, before we get to number one, the person was asking him a question specifically about Jacob Blake. Says, look, this officer shot the guy in the back. Gravely, the district attorney said, you didn't do anything wrong, so we're not going to press charges against the officer. Now, if you've been a follower of this channel for some time, you'll notice that we went back and we were actually on the side of Jacob Blake. Many people were not happy with us about that. Most of our most downvoted videos ever, people were so mad, was about Jacob Blake, but we just went through the facts, and that was my opinion on it. And so this public defender comes out and says, listen, what are you going to do about this? He shot somebody in the back 7 times who was basically running away from him, and now we want you to go and fix this. How are you going to fix this? He defaults to, well, we're going to just pay the public defenders more. So you guys are going to handle that. That's number one. Public defenders get paid more. Number two, they're also going to want to get better police officers, which we've already been talking about. Everybody wants that, and those policy changes have already been underway. Thank you, Joe. We understand that. What he says is we're going to go through, we're going to do a deep study, we're going to investigate what the problems are, then we'll make some more recommendations. And we've already done all of that. I'm so sick and tired of the investigations and the studies and everything. Okay, we know what the problems are. We've already talked about them ad nauseum here. We've talked about qualified immunity. We've talked about mandatory body cameras. We've talked about dealing with the police unions. We've talked about absolute disclosure requirements so that we know who the bad cops are, making some of this stuff publicly available, Brady registries, sharing of data from one agency to another, on and on and on and on. None of that, though. They're going to go study it again, which is just great. So that is very nice. Then we have just another issue of just general systemic racism, which, okay, I can understand that. I understand why that's a political issue. I'm not trying to deny that there isn't any systemic racism or any racism that exists in law enforcement or in our judicial system. But I will tell you this, I see bad things as a criminal defense attorney happen to all people, not just the blacks, the Hispanics, the whites, the Asians. It's everybody. It's across the board. It's a police problem as much as it is anything else. And nobody wants to talk about that. Nobody wants to acknowledge that maybe there's a cultural problem. Okay, I see black cops beating up on black people. I see white cops wrecking white people. I see it across the board. It's a justice problem. It's a law enforcement problem, but they're just going to go back to systemic racism. So in my opinion, 3 non-answers, but that is to be expected. We did learn that, public defenders should get more money. I totally agree with that. And I think that there should be some serious public defender advocacy going on. I just learned recently from a guy on Twitter named Nate Wade, who was telling us, I've never been a public defender. I went right into private practice, but basically they have a lot of limitations on what they can say. They can't go out there and advocate while prosecutors can. So on that point, I agree with that, right? We could absolutely help and support public defenders more. And I've been an advocate for them. A lot of people are come down on public defenders. They say they're public pretenders and stuff like that. And I say, absolutely not. That's not fair. That's not appropriate. So, largely a non-answer. And he was sort of just meandering through it. He also talked a little bit about, if you didn't catch it, he talked about mandatory sentencing. And specifically, he says, well, that was not something that I intended it for it to be that way. He said, black people were being incarcerated and giving much more serious sentences than white people were. 10 years over here, 1 year over here. And so we wanted to just go ahead and modify some of this stuff so that it was more equal, right? It was more equivalent. These are Joe Biden's 3 plans, or his 3-point solution: pay public defenders more, hire better police officers after they do a deep dive investigation, and then end systemic racism, which is all sounds great, sounds good. Not going to solve any of the problems that the questioner was asking him about. Right? Or maybe it would, I don't know. But let's take a look at Joe Biden, what he's mentioning about sentencing, mandatory sentencing and sentencing reform. So I'm going to go through, I'm going to show you all the different crime bills that Joe Biden was a part of. We're going to refresh those, but I wanted to just pause and show you something that we use here in Arizona. It's called a sentencing chart, and it looks like this. And I've explained how this works to a number of people in sort of different settings, and most people are often shocked about this. They just don't understand why this happens. And so what you may have noticed is that you see a couple boxes here, right? And they look like complicated boxes. This is Arizona's sentencing chart. And the way that we do things here is if it's a non-dangerous offense, you get categorized based on whatever level felony you've been charged with. So in Arizona, up until very recently, marijuana violations were class 6 felonies. We just legalized those, legalized most marijuana offenses. If you get an aggravated DUI, you're going to be right here. Okay. It's a class 4 felony. And what can happen is if you are sentenced according to this chart, well, how does it work, right? If you're a first offense, you say this P right here is called the presumptive term, the presumptive prison term. And you just use the chart. You just go down the chart. Okay, class 4 felony. What is the presumptive term? 2.5 years in prison. All right. Even though there are some special rules for DUIs and how those work in Arizona. But generally speaking, if you're charged with a class 4, class 3, class 5, whatever it is, you just figure out what class you're in. And this is part of what Joe Biden installed. I mean, he didn't, come to Arizona and do this, but this is all remnants of the 1994 crime bill and all of the prior bills. So down here, you may have heard of this concept of 3 strikes, a 3 strikes rule, right? Category 1, this would be considered sort of a first strike. Then you've got category 2, sort of a second strike, and then a category 3 would be a third strike. You're now a repetitive offender because you've got prior felonies. And so let's say that you've been charged with a class 4 felony, maybe possession of narcotic drugs, for example, and on your first offense, where you're eligible for probation, then you don't go to prison for that. But if you come back and you've got a prior felony conviction on your record, now you've got 2.5 year presumptive term that you're looking at. Do it again, it goes up to 4.5 years. Do it again, you're looking at 10 years now, right? Sort of the 3 strikes rule. 3 strikes, class 4 felony, possession of narcotic drugs, possession of dangerous drugs happens all the time. They're sending these people to prison for years, for 4.5 years in this case, on a second offense, 10 years on a third offense. And it's just something that is abhorrent to me. Now, when we're talking about mandatory sentencing, then you'll notice that this is just the presumptive term, right? This is sort of where everybody is starting equal. The P stands for presumptive. The government is going to want to increase that. So let's say it's a second offense. You've already got 1 eligible prior. So it's 4.5 years. That is the prison term. the government can ask for as much as 7.5. So they'll try to get a maximum of 6, and they can aggravate the case so you get 7.5. The defense wants to minimize that, so they want to push this back down towards the minimum or the mitigated term of 2.25. And so this whole structure is exactly what Joe Biden is talking about. Now, the reason they put this in place is because they wanted people to operate within the boxes. Right? They didn't want, like Joe Biden was saying, they did not want somebody who was black over here for a judge just to say, oh, some white judge say, I don't like that black guy, so I'm going to give him 25 years. Well, that's not on the chart, right? That's not in the box. So if you box people in on this, then that's good. You don't get those real maximum, really egregious, outside of the ordinary, allegedly racist sentences. But conversely now, let's say you do have a drug addict, somebody who is an addict, somebody who has a serious substance abuse problem, and now they've gotten in trouble a few times. They also have to fall within the confines of these boxes. They cannot get out of the boxes. So let's say somebody comes back, they've got 3 prior drug offenses, they clean their act up, but they're a category 3 offender. And this has happened. I've worked on cases like this where somebody will be a category 3 offender because in Arizona we have what's called a 7-year statute of limitations on drug charges, which means you can be charged for a crime 7 years later. So let's say you're a drug addict and for 3 years you got in a lot of trouble. You got arrested, you got all these things, all these charges pending, filed up against you. You get clean 2 years later, haven't used drugs, totally sober, working a program, helping the community, married, kids, house, whatever. They can bring those charges back up and charge you up to 7 years later. And that has happened. So now they come back and a person who's a category 3 offender is now facing 10 years in prison, okay? 10 years. And when you talk to a prosecutor about this and you say, hey, my client's very good. This person is a recovered addict. They're not a criminal. And they say, oh, well, that's really great. So here's what I'm going to do. I'm going to give you an offer. The presumptive term is 10 years. Okay, you can only go to, if you went to trial and lost, you'd go to prison for 10 years. But since your client is a recovered addict, what we're going to do is we're going to give him the minimum sentence. We're going to go down to 8 years in prison. And you're going, wait, what? He's been sober for 2 years. He's got a wife, 2 kids, a job, the whole thing. You want to send him back to prison for charges that happened 5 years ago? And they say, hey, well, sorry. There's nothing we can do about that because look here, ARS 13703J says, well, we got to operate within these confines. If the defense says, okay, well, we want the mitigated term, that's still 6 years. Okay, it's still 6 years in custody, 6 years in prison. And according to Joe Biden, according to what we're going to go through, this is all the framework from the 1994 crime bill, 1986, 1984, 1982. This created this entire structure throughout the entirety of the country. So we're going to hear from Joe here in a minute that says, well, if you're charged with a drug crime, you shouldn't go to prison at all. So just keep that in mind, right? This is something that he was a part of. And I know it was a long time ago. I know Reagan signed the 80s bills into law. I know this was a whole countrywide movement that both parties wanted this reform to be passed. And Joe Biden was just the spearheader of it. But he was the spearhead of it, right? This is critical to his judgment. This is something that he pushed through and he was proud of it. Year after year after year. This wasn't a one bill in 1994. It was a whole slew of bills. Now, today, fast forward, suddenly the political winds have changed, and he is going to sort of be out there advocating for some major changes in policy. And we're all just supposed to forget about this? I live this. Well, my whole office lives this every single day. Here is Joe Biden from last night, now suddenly saying, well, we shouldn't put people who do drugs in jail. We're going to go back through his record here in a second, but here is Joe from last night.
Good afternoon, Mr. President. Defund the police is discussed as an option for reforming policing. However, there are communities where people live in fear, not of the police, but in fear of the violent gangs who commit crimes in those neighborhoods. How can we be sure that we don't over-legislate police officers so that they can't do their job to protect the law-abiding citizens who live in these high-crime neighborhoods, and yet train officers to police with compassion?
By number one, not defunding the police. We have to put more money in police work. So we have legitimate community policing, and we're in a situation where we change the legislation. No one should go to jail for a drug offense.
Yeah, I
No
agree.
one should go to jail for the use of a drug. They should go to drug rehabilitation. Drug rehabilitation. Number
Cheers,
one.
2021, Joe.
We should be in a
Cheers.
position where we change the system of sentencing system to one that relates to a notion of, they should tell you that, is related to making sure that what you do is you focus on making sure that there's rehabilitation. The idea that we don't have people in prison systems learning how to be spending the money, learning how to be mechanics, learning how to be cooks, learning how to have a profession when you get out. The idea that we deny someone who served their time access to Pell Grants, access to housing, access to, right now, as you well know, most places you get out of prison, you get $25 on a bus ticket. You end up back under the bridge exactly where you were before. And the fact is that the concern in many minority communities is black on black, Hispanic on Hispanic, not just, but here's the deal. There has to be much more serious, how can I say, much more serious determination as to what the background and the attitudes of the recruit is, what their views are. There should be much more psychological testing, like you would if you go into the intelligence community. What is it? What are the things that make you respond the way you do? Because there is inherent prejudice built into the system as well. And we also need to provide for, and it's happening, more African American and more Hispanic police officers. Now, by the way, they don't get it all right either, by a long shot. But every cop, when they get up in the morning and put on that shield, has a right to expect to be able to go home to their family that night. Conversely, every kid walking across the street wearing a hoodie is not a member of a gang and is about to knock somebody off.
Yep.
So it's about education. I'd love to talk to you more about it because it is the answer, in my view, that and education, actually access to education. And one of the things that I talk a lot about, and I'm sorry to go on about this, but it's important, I don't think we can look at our opportunity in the, let's stick with the African American community for a minute, in terms of the criminal justice system. That is only one small piece of why people are the way they are. You realize, I don't know what home you live in, but if you go ahead and you want to get insurance and you're in a black neighborhood, you're going to pay more for the same insurance I'm going to pay for the exact same home. Your car, you've never had an accident in your car. You live in a black neighborhood, you're going to pay a higher premium in your car. So there's so many things that are built in institutionally that disadvantage African Americans and Latinos that we fact, I think, and one of the great advantages, I'm sorry to go on, but one of the great advantages, as bad as things are, I keep reading from presidential historians how I've inherited the worst situation since Lincoln, worse than Roosevelt, because economic crisis, political crisis, racial crisis, et cetera. But the fact is that everyone's gotten a close-up look now and seen what's happened. That kid holding that camera for 8 minutes and 46 seconds awakened the whole world. When I met with his little daughter after he was dead, she said, "My daddy's changed the world." Guess what? Not only here in the United States, around the world, people said, "Whoa, I didn't know that happened." Dr. King, when my generation, when I got involved in the civil rights movement as a high school student in the early 60s, and you had Bull Connor and his dogs in the late 50s singing on those ladies going to, in their black dresses going to church and little kids.
All right, I have no idea what the hell he's talking about now. So, this is, all right, so let's recap what Joe was talking about there. So, number one, the person asks him specifically about the fear of gangs. He says, well, the police, we don't want to we don't want to tie their hands. They need to go out there and do their job. And he says basically a couple things. He says, well, no jail for drug offenses. All right. So, okay. Then he also says, well, no denial of higher education for the inmates. Then he goes into sort of a third part of his answer where he's talking specifically about psychological profiling for the police. So I didn't think it was actually responsive to the gentleman's question, but that's all right. Then he goes on and he talks about learning and how important it is, psychological testing. and on and on and on. So this is sort of a synopsis of what his solutions are. No jail for drug offenses. And he also says no denial of higher education. And then he also says a little bit more about psychological testing, right? That's sort of a thing in there. It's psychological testing for the police. But don't defund the police, something that I've agreed with a lot. I've talked about this a lot, about higher education. Really, a lot of what he said there, I empathize with. I actually agree with a lot of that. I've said many times on this channel, I don't want people going into custody and coming out worse, coming out even worse off for society. Okay, we don't, the punishment is the removal from society. It is the segregation of them into their own little house. They lose a ton of freedoms. They're not able to go out and spend time with their spouse or go, have a job that's at a normal facility. They are in prison. That is the punishment. But we don't want them to come out worse than when they went in, because we put them in there in the first place because they weren't, apparently good enough for society. They had to be removed from society when they come back into society. Wouldn't it be nice if they had a nice skill set? Joe Biden was talking about it. Yeah, cooks and cleaning and all this stuff rather than a $25 and a bus ticket. Totally agree with that. Also, totally agree that nobody should be in jail for drug offenses. Okay, unless they're, manufacturing meth or something like that. That's a separate claim. But if somebody is an addict and they're using drugs, why are we punishing people by throwing them in prison when it's a pain thing, it's an addiction thing? I think there are better ways to deal with that. So let's once again revisit Joe, because he made some pretty nice claims there. This is what he had done previously. These are his bills. Co-sponsor Anti-Drug Abuse Act, 1988, another Anti-Drug Abuse Act, then in 1994. So let's go through some of these, shall we? The 1984 Act, this was the Sentencing Reform Act. This is where we got some of the mandatory sentencing, even though he said it shouldn't have been there. This was an extension of the Secret Service jurisdiction over credit card fraud. But look here, we have increased federal penalties for cultivation, possession, or transfer of marijuana. Right? So that's good. So in 1984, I know it was a long time ago. I get it. And I understand that people's opinions evolve. But there are a lot of people sitting in prison because of this bill that Joe Biden was a co-sponsor on. Then we have the 1986 bill. This was a solution to the recreational drug use, which was to punish the casual user. And if you don't like my phrasing on that, then you can go take a look at the congressional bill, right? This is sort of a synopsis of the bill. Mandatory minimum sentences on the type and quantity of drug used. Then they wanted to increase the penalties for trafficking in synthetic drugs. Then they set mandatory minimum sentences for drugs, including marijuana. This was all done on a federal level, 1986. Go look it up if you want to. Joe Biden was highly involved in that. As he said, every crime bill from 1976 on through 1994 had his name on it. He was leading the charge on it. Then we get 1988. It is the policy that we have a drug-free America. Remember, we got the DARE program and all this stuff going on in schools. It amended the 1986 Act because it wasn't harsh enough. So then what they did is they created a mandatory minimum penalty for first offense possession of crack cocaine. First offense. Lock them up. Lock those SOBs up, according to Joe. And it was for crack cocaine. Do you know what community was hit hardest by the crack cocaine epidemic? The African American community. Do you know what happened to those people on a first offense possession? They went to prison. There are probably still people in prison as a result of what happened under these laws. Joe Biden's the president now. He's got both houses of Congress. Maybe it's time for them to do something about it. Then also, according to this bill, allow the death penalty for anyone murdered during a drug felony. So and then toughen penalties for drug users. That was in the 1988 crime bill. Then we get over to the 1994 bill. This is the largest crime bill in the history of the United States. It consisted of 356 pages, 100,000 new police officers, $9.7 billion in funding for the prisons, $6.1 billion in funding for prevention programs. Joe Biden literally drafted the Senate version of the legislation in cooperation with the National Association of Police Organizations. So for over 10 years now at this point in time, he's been just grinding, locking up all the drug addicts, punishing people with mandatory minimums, making sure that sentencing was uniform across the board, set up the framework for the 3 strikes proposals that you see throughout the country, all directly related to Joe Biden. Then today, yesterday he's talking about, well, education. I mean, we got to have education for these people. He goes through, makes a big point of it. I want to make sure that they learn a skill set so they can, improve themselves when they come out of custody. Well, that would have been nice. I would agree with that. I think it's a very nice sentiment. I'm very happy that 2021 Joe Biden is on board with that, because in 1994, that was not the case. Here was an excerpt from Wikipedia. This is still over there on Wikipedia. Go look at it. It says the Violent Crime Control and Law Enforcement Act, elimination of higher education for inmates. So they literally wrote that into the bill. One of the more controversial provisions of the Violent Crime Control and Law Enforcement Act overturned a section of the Higher Education Act of 1965, permitting prison inmates to receive a Pell Grant for higher education while they were incarcerated. The amendment is as follows. Subsection A, in general, Section 401B8 of the Higher Education Act is amended to read as follows. Subsection 8, no basic grant shall be awarded under this subpart to any individual who is incarcerated in any federal or state penal institution. It effectively eliminated the ability of low-income prison inmates to receive college educations during their term of imprisonment, thus ensuring education levels of most inmates remain unimproved over the period of their incarceration. So we fast forward now, 20-something years. Now Joe Biden is all on board criminal justice reform. But, folks, I have a hard time just letting this stuff go, because it's, quite frankly, I don't think he's going to do anything about it. I think that this is all a bunch of bloviating talk. He's got all three branches he's got the legislative branch, both houses, and the federal White House. He's the president of the country. And he's talking about systemic racism, okay? He passed these laws. These are in writing, recorded in Congress. He can undo all of it. It's very damaging. He's talking about problems that he created over the last 30 years. And we'll see if he does anything about it. But this is one of those things that I just can't let him get away with it. I'm very happy that he is now coming to terms with this. I'm very happy that he's now talking a big game and saying we're going to start looking at some of this stuff. But until it gets done, I'm not going to hold my breath. And anytime he comes out there and starts claiming, that there are other causes of this, or that he was not responsible for it, that this is just society that just sort of developed this way. No. For a decade, you were passing literal legislation that was changing the way that we do justice in this country. Now, you got to reap what you sow. The whole country is angry about it. For some reason, I don't know why, but the media just let this stuff all lie low. Donald Trump, to his massive failure, they didn't beat him up over this stuff over the last campaign. But I think if more people knew about what Joe Biden was responsible for in America, all of this malfeasance that we see day in and day out, all of the trials and tribulations that anybody who's been charged with a crime has to go through, the type of work that we do here at our office to help people survive and succeed in the justice system, we're fighting back against Joe Biden's legislative agenda, against his policy. I'm hopeful that it changes, but I'm not going to hold my breath. All right, so enough of that. Let's change gears a little bit. This next story comes from the Gateway Pundit, which is a very interesting website, but they did a good article on this one today. They're talking specifically about this fellow by the name of John Earl Sullivan. And this was a guy, he actually looks like this, who was a part of the Capitol Hill riots. Remember, he was sort of dressed up in Trump gear, and I think this was one of his mugshots, and this is what he put on, and they were there. And a lot of the groups are disavowing this guy now. People are trying to figure out who is he a part of. Is he part of Antifa? Is he part of BLM? But apparently, according to the Gateway Pundit and one of their reporters, they say he's an insurgents leader. He was arrested in Utah, and we talked about his case after the U.S. Capitol riots. As previously reported by Antifa protester, he was caught on video posing as a Trump supporter during the rioting at the Capitol on January 6th. And so we're going to go through some of this article. They're basically pulling from other websites, but they had the documents. So I got the documents from them, so I wanted to give them credit for this. And here is what the Gateway Pundit says. Footage obtained by the Gateway Pundit from militant Black Lives Matter and Antifa activist John Sullivan's Discord server shows so-called civil rights activists reveling inside the U.S. Capitol as he damaged federal property. He has maintained in multiple interviews that he regularly attends protests only to record what's going on, but did not actively partake in the insurgents in Washington. That's a lie. He's the leader of the Utah Antifa BLM movement, and he has previously been arrested. He organized an Antifa insurgents rally on January 6th at the Washington Monument at 11 a.m. before they stormed the Capitol. The mainstream media refuses to report these facts. On Tuesday, political reporter Kyle Cheney reported that John Sullivan was paid $35,000 from both CNN and NBC for his footage inside the U.S. Capitol on January 6th. And so Kyle Cheney then, he says, these are the invoices filed with the court today. And you'll look here, you'll see this document filed yesterday on February 16th, page 2 of 4. It is a non-exclusive license agreement. The licensor is John Sullivan, so he's the one who has the video footage that he wants to make available. He says this agreement is entered on January 6th, so the same day that it happened, between the licensor, which is John Sullivan, and the cable news network, or CNN. CNN is entering into a contract with an insurrectionist, allegedly, right? Grant of rights for $35,000, the receipt and sufficiency of which are hereby acknowledged. Here's what they're going to be getting. Quote, the eyewitness video of the shooting at Capitol Hill on 1/6/2021, collectively known as the materials. They can do whatever they want with those things, and they're granted usage rights starting on January 6th. Goes further, licensor represents, warrants to CNN that they've got full legal right, power. In other words, John Earl Sullivan has the ability to transfer this stuff, and he's doing so, signed off on here by John Sullivan, governed by the laws of the state of Georgia. All right. They're going to hold harmless CNN. So CNN paid $35,000 for his footage. NBC did too. Here's NBC's. NBC Universal says this is another one filed. So an ACH payment has been initiated from NBC UACH notification at NBCUni.com. So notification of an ACH deposit. It's a bank transfer. It's a wire transfer, right? It says the vendor ID. We got John Earl Sullivan. We got the last 4 digits of his bank account number. Guess what? Another $35,000. NBC Universal invoice date $35,000. Another $35,000. Guy made $70,000 from his footage, and NBC and CNN paid him $35,000 a pop for that. Is that curious? Is that just me? Am I just curious about this? Taylor Hanson, a Gateway Pundit contributor who was also at the Capitol Hill protest. Taylor is an actual videographer and reporter, unlike John Sullivan, who is an organizer. Taylor told us, quote, this raises serious red flags. Taylor told us that the average beat reporter and videographer makes $300 to $1,000 for coverage from an event like the U.S. Capitol riots. Sullivan made $35,000 for his coverage. He said, with over 6 months of experience as an independent journalist, which actually isn't that much, right? I have captured some of the most viewed and circulated media content on the internet. I have never made over $1,000 on an individual video. The highest I've ever seen a news source pay for breaking news footage is $3,000. John Sullivan being paid $35,000 by CNN and NBC for one event is criminal, he said. Well, I don't necessarily agree with that. An average paid journalist out of Utah makes $3,000 a month, not $75,000 in a matter of days. Well, that doesn't matter. Let's not forget that John has always been an Antifa and BLM organizer. He was never reported in journalistic capacity. Even while reporting, he's seen breaking a window, telling people he has a knife to get in front of the crowded hallway, and he's heard saying, let's burn this S down, which we've covered. We talked about John. We talked about his whole case. I think we went through his entire arrest warrant and all of the original charging documents. John Sullivan has never been a journalist. He's a vowed BLM supporter. There's something nefarious going on here. I intend to find out what it is. So, I'm not a journalist either, but that sounds like a pretty nice payday, right? $75,000. Certainly he can use that to afford a good defense attorney, which he is, of course, going to be needing because he is now under, I think, federal indictment. So interesting story there. I don't know if there's anything more nefarious going on. It was a sort of once in a lifetime event, so I can understand paying more than $1,000 or $3,000, but $35,000 for that? Wow. That is interesting. Isn't that interesting? All right. Let's change gears yet again. As I mentioned, we have a very outstanding contributor to the program who goes by the name of Chris Wiseman over on Locals. And he posted this earlier today. He said, this would be hilarious if it weren't so gruesome. Man douses himself in gasoline, threatens to kill himself. This was posted by Akchara over on Twitter. And he was referencing us over here to this case from the U.S. Court of the Fifth Circuit. It's a qualified immunity case. Cop number 1, he said, quote, if we tase him, he's going to light on fire. Cops 2 and 3 say, well, okay, tase him. Man lights on fire, burns alive. House also burns down. Fifth Circuit says qualified immunity. He was threatening arson. Therefore, you're allowed to torch him. You're allowed to torch down the rest of the property. That sounds nice, right? Sounds kind of on point. So let's get into first of all, thank you, Chris, for alerting us to that. Let's go through the opinion. This came out about a week ago, and I think it's important. It's an interesting one to read. And it says here, the United States Court of Appeals for the Fifth Circuit filed February 8th. It's Selena Marie Ramirez. She's the independent administrator on behalf of the estate. So the person who died is Gabriel Eduardo Olivas, and got different heirs at laws. And so what is happening here is Selena Marie Ramirez is suing the officers, okay, for killing him. Let's go through the facts. And this is before Jolly, Stewart, and Oldham, who are all circuit judges. Pure curiam, so it's sort of the opinion of the court. This case arises out of the tragic death of Gabriel Olivas. While responding to a 911 call that Olivas was threatening to kill himself and burn down the family's house, we have officers Guadarrama and Jefferson. They discharged their tasers at Olivas, striking him in the chest. Olivas had doused himself in gasoline, which ignited when the prongs of the taser came into contact. He was engulfed in flames. The house was burned down. He died of his injuries several days later. His widow and 2 children were subsequently brought suit. They said that they violated his Fourth Amendment rights when they tased him. They asserted that the officer said, nope, we have qualified immunity, and they moved for dismissal. But the district court, the lower level court, remember this is on the Fifth Circuit Court of Appeals, they denied the motion to dismiss the case. They said, no, we need more factual development. The officers then filed this appeal. We reversed the denial of qualified immunity and remand to district court with instructions to dismiss based on the claim against the 2 officers. With this background, we now go on to explain further. So, quick recap. We have Gabriel, who is at his home. Apparently, he's covered in gasoline, threatening to burn himself and kill himself and burn the house down. Cops show up, some sort of altercation. They tase him. He ignites because he just got jolted with volts of electricity. Something happens. He goes back to the house. House burns down. He dies a couple days later. Burns all over his body. Family says, all right, well, that's it. So cops shouldn't have done that. You knew better. Shouldn't have happened. And they sue. At a lower level district court, the lower level court said, no, this needs to go forward. We needed to develop the facts more. Cops said, no, this should be dismissed because we have qualified immunity. We are immune from lawsuit. We're not liable for that damage. We're not responsible for what we just caused there because they have certain levels of immunity. And so this court goes on. It says, upon entering, Officer Guadarrama detected an odor of gasoline. A woman directed the officers to a corner of the bedroom on the east side of the house. They found Gabriel there, leaning against the wall and holding a red gas can. After turning his flashlight on, Officer Elliott allegedly shouted to Sergeant Jefferson and Officer Guadarrama, quote, if we tase him, he is going to light on fire. Okay, so they knew that this was a real thing. They knew that this could lead to this outcome. This was foreseeable. It was predicted. It was discussed. Elliott then discharged OC spray in Olivas' face, temporarily blinding him. It was at about this point, whether before or after being sprayed is not entirely clear from the record, that Olivas doused himself in gasoline. Guadarrama and Elliott, at least, maybe Jefferson as well, noticed that Olivas was holding some object that appeared as though it might be a lighter. Guadarrama, followed in short succession by Jefferson, fired his taser at the gasoline-soaked man, causing him to burst into flames. We've got Colonel Ray, Officer Scott arrive at the scene at about this time. When they entered the house, they found him engulfed in flames. The fire spread from Olivas to the walls of the bedroom. The house eventually burned to the ground. The officers at the scene were able to evacuate the family members who had remained in the house, but he was so badly burned, he later died from his injuries. Olivas' wife and son subsequently brought suit, saying that the officers violated his Fourth Amendment rights when they tased him. Each of the officers said, no, we're immune. We have qualified immunity as a defense, and they moved for a dismissal according to Rule 12b-6. Failure to state a claim. The district court denied their motions, finding that more factual development was needed. Then we get into some qualified immunity analysis, and I want to spend a little time on this. They say here that qualified immunity has 2 components. Number 1, whether a plaintiff, so the person who's filing the lawsuit, whether they're showing or alleging that the violation was a violation of federal constitutional or a statutory right. So they need to get very clear on what is being violated. And then number 2, whether the right in question was clearly established at the time of the alleged violation. All right. And I want to just show you briefly sort of what that might look like. So we have a little bit of new technology here on the show. Let's see if I can make this work. So we're talking about qualified immunity. And what I want to do is just draw a line right here. That is the qualified immunity line. So we're going to say this is the QI line. That is qualified immunity. Anything that's above the line is okay, and anything that is below the line is bad. That's not okay. The court is going to say that's not good. We're not going to allow that to happen. And as we're going to go through here, you're going to see that the courts are sort of defining the different categories. So it says whether the right in question was clearly established. And so when we're talking about this in the context of a lot of the crimes that we've spoken about here, right, you can make the argument that, well, let's take some examples of cases that we've covered here. We just heard from the questioner at Biden's town hall that the DA gravely dismissed any charges or refused to file charges against the officer who shot Jacob Blake in the back 7 times. Okay, so was that officer immune from criminal charges? Yes. So we can put Jacob Blake up here above the line, right? We'll put Jacob Blake up here. He's above the qualified immunity line. There was nothing wrong with what happened there. Now, George Floyd, we still don't know, right? George Floyd is still sort of pending, but we're probably going to guess that goes down here. George Floyd, the police officers did not have qualified immunity to lean on his neck for 8 minutes and 46 seconds. Okay, same things. Other cases are still pending. Ahmaud Arbery, remember that one where there was that young man who was running through the streets. Other police or other people who used to be police officers, they came, they ended up shooting him, and now they're being charged with crimes. So Ahmaud Arbery would certainly be below the line because the qualified immunity standard, whether there was a right that was clearly established that the police didn't violate, that is below the line, right? So Ahmaud Arbery would be below the line. We got Rayshard Brooks, probably below the line. They're not going to get qualified immunity for that. He was running away and he got shot in the back. Breonna Taylor, though, right? Breonna Taylor, what happened there? All of those cops, they were basically immune. Now they didn't get away on the qualified immunity statute because they just were not indicted. There was no case actually brought against them. But they are above that line. So we got the Breonna Taylor case here, which is also sort of it's okay. It's acceptable. And so what the court is going to do is they're going to try to distinguish this. And so sometimes this line will actually move. They'll say, all right, well, we're going to protect more of this content. We're going to raise this line up just a little bit. And then sometimes in other courts, they'll move it down for different conduct. And so we're always trying to figure out where this line is because it is sort of moving. It's changing around. And we had talked about specifically cases from Amy Coney Barrett, our newest Supreme Court justice, and she was sort of making that line smaller, making it less applicable to some additional conduct. In other words, the police had not defined that was a clearly established right at the moment, and therefore they're not going to be held accountable, or they are going to be held accountable because qualified immunity doesn't apply. So I don't know if that makes any sense, but that's sort of how I was thinking about it as I was reading this opinion. It says here, since Pearson, a reviewing court may tackle these questions in whatever order it deems to be most expeditious. The second question, addressing whether a right is clearly established encompasses another question discussed separately in the court's opinion. In order for a right to be clearly established, the contours of the right must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. Okay, so let's think about what we might be talking about here. Did he have a right to not get shot with a taser when he was covered in gasoline? All right. The reasonableness of the official's conduct and the degree to which the particular right in question was clearly established are thus merged into one issue for the purposes of qualified immunity analysis. The opinion goes on. We view the disputed facts in the light most favorable to the plaintiffs. Guadarrama, Jefferson Elliott arrived at the house in response to a 9/11 call, having been told that Gabriel was threatening to kill himself and burn down the house. They found him in a bedroom that smelled of gasoline. He was holding a gas can. Officer Elliott shouted, quote, "If we tase him, he's going to light on fire." Elliott then discharged OC spray, temporarily blinding him. Gabriel began to shout nonsense and yell that he was going to burn the place to the ground. He poured gasoline over himself. At some point before either taser was discharged, Officer Guadarrama and Elliott noticed that in his hand he appeared to have a lighter. They fired the taser, striking him in the chest. He burst into flames. Jefferson then fired his taser, which also struck Olivas in the chest. So they didn't want him to light himself on fire, so they lit him on fire. Am I reading that right? All right. Having set forth this factual background, yeah, he had a lighter in his hand. It wasn't a gun, right? It wasn't a knife. It was a lighter. Appeared to be a lighter. They didn't want him to light himself on fire, so they lit him on fire themselves. Having set forth this factual background, we now consider the reasonableness of the force that was employed. Graham sets forth specific factors to be considered in the reasonableness inquiry: the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of officers or others, whether he is actively resisting or attempting to evade arrest by flight. Here, the severity of the threatened crime, quote, felony arson, was considerable. What a joke. What an absolute joke. He posed a substantial and imminent risk of death and serious bodily injury to himself and everyone in the house. Well, they had multiple officers there. They could have escorted them out of the house immediately. That would have negated that. He was covered in gasoline. He'd been threatening to kill himself and burn down the house. He appeared to be holding a lighter. At that point, there were at least 6 other people in the house, all of whom were in danger, which is a crock, right? They could have gotten them all out. Other officers were arriving. This didn't happen in 10 seconds. The final Graham factor of the reasonableness inquiry is whether Olivas was attempting to flee or evade arrest, which is not of relevance here. No, of course not. This is from the Fifth Circuit Court. These are really renowned judges. Although the employment of tasers led to a tragic outcome, we cannot suggest exactly what alternative course the defendant officers should have followed that would have led to an outcome free of potential tragedy. Well, let's see if we can think of one. Well, they could have just sat there, right? They could have just sat there and let him light himself on fire. If he wanted to light himself on fire, they could have just said, all right, well, we're just going to stand here for an hour and do it then. Do it. Okay, could have called a psychologist in there, a community response team, a hostage negotiator, anybody to have a conversation. Could have called the neighbor, could have brought the wife in, right? Could have just had a simple conversation with the guy. It sounds like he was just sort of in the corner, covered in gasoline with a lighter. If he wanted to light himself on fire, yeah, there's going to be no liability for the police there, but they could have just stood there. They didn't have to do something. This is one of the biggest problems that I hear anytime that people want to come and defend the cops on this channel or anywhere. Well, they had to do something, right? The 9-year-old girl who got pepper sprayed in the face, well, she wasn't cooperating and that's her fault. And we have to do something. We can't just sit here and deal with this. We got other places to go. Okay. Or you can just wait. You can just hang out for an hour, let her calm down. She's having a panic attack meltdown because she thinks that you just shot her father or whatever the story was there, or the mom stabbed the father or something like that. You don't have to just diffuse every scene immediately with the use of force. You can just stand there. If he wants to light himself on fire and burn the house down, that's fine. Get the other people out and manage the situation. Am I off on that? The Fifth Circuit Court couldn't figure that out. The police have to take action in a situation like this. They can't just stand there. We emphasize that the reasonableness of a government's official use of force must be judged from the perspective of a reasonable officer on the scene, not with the benefit of 20/20 hindsight. Well, yeah, I mean, a reasonable official on the scene said if we shoot him, he's going to light on fire. So we know that was kind of a known fact. The fact that Olivas appeared to have the capability of setting himself on fire in an instant, and indeed was threatening to do so, meant the officers had no apparent options to avoid calamity. If reviewing the facts in hindsight, it is still not apparent what might have been done differently to achieve a better outcome under these circumstances, and certainly we, who are separated from the moment by more than 3 years, cannot conclude that Guardarama or Jefferson, in the exigencies of the moment, acted unreasonably. Okay. Given that Guardarama fired first, the most readily apparent justification for the use of his taser was to prevent Olivas from lighting himself on fire. So they lit him on fire. They helped him with that. They wanted to stop him from lighting himself on fire, so they lit him on fire. Jefferson fired second, while at one point he claimed to have fired instinctively. Plaintiff alleges that he did so intentionally. Accepting plaintiff's allegations is true. Jefferson still has good reason to try to immobilize Olivas, to prevent him from spreading fire around the house. But they did that. The police did that. They lit him on fire, and then it spread around the house. So what did that work? Moreover, at that point, there was no risk that using a taser At that point, there was no risk that using a taser might ignite a fire since Olivas was already engulfed in flames. So that was after the second person shot, right? So the second guy is, he definitely doesn't have any fault. And I actually agree with that, right? The first person who fired the taser, they ignited him. Somebody else warned him, hey, if we shoot him, he's gonna ignite, and they shot him anyways. The second person was just after the fact. All right, well, he's already torched, so why don't I just shoot him as well? Maybe that'll help. Accepting the pleaded facts as true and construing them in a light most favorable to plaintiffs, neither officer's conduct was unreasonable, nor was the force they employed clearly excessive. We thus find that plaintiff's factual allegations do not make out a violation of his Fourth Amendment rights. The plaintiffs have asserted that the officers violated the Fourth Amendment rights of their deceased husband, father, by using excessive and unreasonable force. Officers have invoked qualified immunity from the lawsuit, arguing there was no constitutional violation because their use of force was reasonable under the circumstances. We have found that given the horrendous scene of the officers were facing involving the immediate potential for destruction of lives and property that they caused, that it was not unreasonable. We hold the officers did not violate the Fourth Amendment. They are thus entitled to qualified immunity. For the reasons given, we will reverse the order denying qualified immunity and send it back down to dismiss all the claims against the officers. All right, so when we go back to our little chart over here, we can just say you also get qualified immunity for lighting people on fire for the police. So you get qualified immunity for that, so you're good. So cops, now you know, just light up whoever you want. You're immune from that. Well done, Fifth Circuit. Last story of the day before we take a couple questions is over from New York. The New York Police Department is, they're probably a little bit upset right now because a new court ruling just came out and said that they are not allowed to bargain away, to negotiate away their obligation to disclose certain materials. So the way that this typically works, right? The police department, they know what officers have gotten in trouble. They are the only ones that really know. They're the police department. There's no there's no real lists anywhere that we can all sort of just go check on officers. There are lists that prosecutors will provide periodically, but this is a problem that I've been talking about a long time on this channel. I've said repeatedly, police unions are a huge part of the problem because when they enter into negotiations with cities and say, hey, we're going to come and provide policing services for you, but we want these terms. We've got, 1,000 officers here who are part of our union. City council, if you want our services, well, we're going to have to enter into a pretty robust contract. And as part of that contract, we want to make sure that our officers and their prior records, their disciplinary proceedings, any of those, anything that they did bad in the past, we don't want that brought forward because, we got to protect our officers, right? We got to protect our police. They're good people, blah, blah, blah. Whatever their justification is for allowing bad, disciplined, sanctioned officers to continue being on the force, they've got a justification for it. I don't understand it at all, but they have it. And the city council just buckles for them. They just say, all right, well, how about 5 years? After 5 years, we're just going to scrub their records clean. They say, okay, no problem, cool. And we're going to go in there and then we're going to have a police force. That same situation happened here in Arizona. After 5 years, a lot of police departments, the Phoenix police, right, the biggest police department here in Arizona at least, was just scrubbing their records. So if you just made it past that hurdle, you were in the clear. Nobody would know about anything that you did prior to that. Awful. And then people wonder, Joe Biden wonders, why is this stuff such a problem throughout this country? Well, it might be the unions. And in New York, the unions suffered a massive defeat as a federal court said, you cannot do that anymore. You cannot continue to bargain away your constitutional duty under the Brady rules, Supreme Court precedent to disclose conduct, to disclose evidence of your own misconduct or malfeasance. This article came over from Law and Crime, written by Colin Kalmbacher yesterday, says unions representing the New York City Police Department officers were dealt a decisive loss in federal court on Tuesday after unsuccessfully suing to keep in place a regime of state secrecy that benefits law enforcement at the expense of public transparency. This happens everywhere. This case stems from a 2020 rollback of Section 50-A of New York State's civil rights law, a law which was used for decades by police departments across the Empire State to withhold individual police officers' disciplinary records from the press, even after officers had been credibly accused of bad behavior. This happens all the time. I complain about it. If you go back, months and months and months ago, I used to hold these officers' pictures up. Now we use PowerPoint. Hold them up and say, hey, remember this guy? Because the media wouldn't cover it. The police don't disclose their names. They don't tell us who they are. They just try to keep it all hush hush. Meanwhile, many of these guys and gals are out there still being a part of law enforcement, still making arrests, still citing people. still prosecuting cases, even though they themselves are in trouble. They violated their own policies and procedures. But they do everything they can to sweep it under the rug. The reform-focused impetus behind revoking the statute was consistently stalled out under the administration of New York Governor Andrew Cuomo for several years, until a critical mass of support for striking down the law came after George Floyd. Right? So all of these jokers in our government who say that they are all about criminal justice reform, they're really sorry about George Floyd, they want to do better. Let's have a conversation, everybody. Let's just talk about it. Let's form a commission, Joe Biden. Let's have a lot of people just study this issue and take a look at it. Well, you've got some stuff that was already underway. Andrew Cuomo, you could have done something about this, but you didn't. You stalled it. Because it's all talk. There's no action from any of these people. Well, until George Floyd happened, now they are trying to do something about it. Once 50-A was off the books, New York City announced plans to, quote, proactively publish certain types of disciplinary records and provide other records upon request consistent with its obligations under the New York Freedom of Information Law. The Second Circuit Court of Appeals noted in a summary order several law enforcement unions sued to keep multiple forms of disclosures under wraps. Law enforcement unions sued to keep multiple forms of disclosures under wraps. So when people ask, what can we do to solve this Justice Department, this justice problem that we have, this criminal justice issue that we're seeing all over the country, and we talk about getting bad officers off the force, why are they not going anywhere? Because of unions. And you see it right here. The unions are doing everything they can to keep those disclosures under wraps. They don't want you to know about it. In July and August of 2020, U.S. District Judge Catherine P. Fiala ruled against the unions. She ultimately denied the motion in substantial part, but granted police groups a narrow victory by enjoining a small subset of certain records from disciplinary trials where a police officer is determined to be not guilty. Right? I think that's pretty reasonable. Okay, if you're acquitted on that, if you've had a formal process, I, as a defense attorney, would still like to know that you had the proceeding. Remember, if you're charged with a crime, at least in Arizona and California, you can just go look up those records on the internet. You can go look up somebody's name and say, okay, I can see exactly what that person was charged with. And when they have court next, I can see who their attorney is. I can see what the charges are, how long the case has been going on. All of the stuff that we cover on this channel very regularly is just public records, whether it's Rittenhouse, whether it's the Floyd stuff. We've been following Derek Chauvin for some period of time. It's all public record. Unless you're a cop, okay? If you're a citizen, then it just goes behind the scenes. Unless you're a cop like Derek Chauvin, who's been arrested, national media. Right now, he's the subject of an entire inquiry. He's been charged with a crime, so his records will also be public. I'm not talking about that. I'm talking about the police misconduct. When the police violate their own protocols, they're a part of the government. When they go through their due process, it's all kept behind closed doors. All these little, subcommittees here and there, and they all just kind of keep things secret, but we can't see any of it. But if you get in trouble, it's front and center. In fact, they may even put your mugshot on the internet. Just for good measure, just to rub it in. But if a cop gets in trouble, not so much. Everything gets swept under the rug. The NYPD and others had argued that they would be irreparably harmed by the release of such records. Okay, but both the lower court and the second court found that line of argument unpersuasive. The unions assert that law enforcement officers will have fewer employment opportunities in the future if records of the allegations against them that prove to be unfounded or unsubstantiated are disclosed, even though each record will reveal the outcome of the investigations, the appeals court said. Okay. But the district court noted that future employers were unlikely to be misled by conduct records that contained dispositional designations specifying that allegations of misconduct were unsubstantiated, unfounded, or that the accused officer was exonerated. Right? Just like anything else. You can do that. If you've been charged with a crime and they find that on your background record and you walk right in and you say, yeah, I was charged with that. Here's my dismissal notice. Okay, I was adjudicated and found not guilty. What other questions do you have about it? I'm happy to talk about it. It was bogus. It was an unlawful charge. I beat it. And everybody should go. I mean, in my opinion, I'd say, okay, good. It's great. Happy for you. Thank you for clearing that up. Apparently, that's outside of the scope of what the police are allowed to do, what they can do. The panel went on to note that numerous other states make similar records available to the public and ultimately found that, quote, the unions have pointed to no evidence from any jurisdiction that the availability of such records resulted in harm to employment opportunities. NYPD also lodged a more general grievance against transparency, arguing that the release of disciplinary records would result in heightened danger and safety risks to police officers. What? The court dismissed those as wholly unfounded as well. We fully and unequivocally respect the dangers and risks police officers face every day, but we cannot say that the district court abused its discretion when it determined that the unions have not sufficiently demonstrated that those dangers and risks are likely to increase because of the city's planned disclosures. And arriving at that conclusion, we note again that many other states make similar misconduct records at least partially available to the public without any evidence of a resulting increase of danger to police officers. Yeah, it's because it's not more dangerous to them. How is it more dangerous to them? Okay, they have all of the records, folks. They have them. We don't get them. They're in control of it. They investigate themselves. Most of the time they find that they did nothing wrong and everything's fine, everything's good. But if you're charged with a crime, if you're a defendant, if you're somebody that this government is coming after you for, wouldn't you want to know whether that officer who just pulled you over and charged you with the DUI, whether a year ago, 2 years ago, 5 years ago, 10 years ago, whether he did something similar, whether he was inappropriate with somebody on the side of the road, whether he's got a history of, racial profiling, whether he's broken policies before. This is a huge one. What if a police officer breaks a policy? Okay, they have a procedure in place and they break that. That opens the door to a lot of problems in any criminal case. If they're going to break a policy on something stupid, well, then why wouldn't they break a policy when they're analyzing your blood sample or drawing it out of your body, or when they're testifying under oath that they saw you violate a law on the road and that was their justification in order to pull you over? And then they make up something else about smelling something on your breath. Boom, that leads them to probable cause. They ask you out of the car, field sobriety test, more probable cause, arrest, take you to jail. Now you get charged with a DUI. Well, what if that officer has already broken policies? What if that officer already has a history of malfeasance, of lying, of bending the truth? And we as defense attorneys can't see that. We just don't, it's not anywhere to be found because it's not publicly available. Well, fortunately, the Second Circuit sounds like they have helped clear some of that up for these people out of New York. This is the final summary order that you'll see here. Second Circuit Court of Appeals. Appeal from an order is affirmed. So that's good news. Little good news here today. A lot of terrible criminal justice news today, but that was a good one. All right, we're going to take a couple questions. As I said, I've got a board meeting tonight, so I've still got some prep I got to do on that. So we're going to fly through some of these questions. Thank you for understanding. Our first one comes from Seawolf74. How impartial can we really believe public defenders to be when they're paid and work for the same government as the police? It's a good question, Seawolf. It's a criticism that I've heard before. I can only sort of tell you this. The public defenders that I've known and interacted with, that doesn't even really come into the equation at all. I think sometimes, you have to understand, I think context is important. So if you're in a situation where it's a very small jurisdiction with a small court and you've got, 2 prosecutors and 2 public defenders and a judge and that's it, that's pretty small, right? That's pretty intimate. I actually would have some concerns about that. I have concerns about that already when it comes to prosecutors and judges. There are some courts in Arizona where the prosecutors' offices and the judges' offices are literally in the same building and they're all using the same technology and the same systems. That's troubling to me, right? If they're all on Slack, instant messaging each other all day, well, you're going to develop a relationship there, and you should have a very strict line of separation between the two agencies because you don't want that commingling because you have conflicts of interest. If they're in the same building, they're going to run into each other in the restrooms and going to lunch and on the weekends. I'm just stopping in to grab my coat. Oh, hey, Susan, how are you? Right? Prosecutor and a judge, and they form these little bond type of relationships. I will tell you this, though. When you have a big city like Maricopa County, it is really, really big. And I think that actually helps create those divisions to some extent, right? We have a public defender's office that is just a public defender's office. That's it. Right? There are no prosecutors there. There are no judges there. It's just their building. Then you go down around the block, you've got the Maricopa County Attorney's Office, which is where the prosecutors stay. All the judges have their tower in the courts. And so now you've got a little bit more separation. And I will tell you that at least in Maricopa County in Arizona, The public defenders that I have speak with, I'm friends with many of them. They are they're believers. They're sort of true believers. They have a general disdain for a lot of prosecutors. Prosecutors have general disdain for criminal defense attorneys, and that's just perfect. That's exactly what we want. We don't want this buddy system that everybody is just sort of playing patty cake with one another. It's an adversarial system for a reason. You should be going at it hard in court, and you can break after the case is over and be friends and go have a coffee or a beer or whatever it is. But when it's time to play ball, you want to get out there and be aggressive with it. And my experience with public defenders is, at least here in Arizona, they are true believers. They're not out there to just sort of move cases along. Now, within the public defender arena, right, you're going to have good public defenders and mediocre and bad public defenders, just like you have the same thing with prosecutors, just like you have with doctors or sports teams or private defense attorneys. So you have to keep that in mind. I have met some outstanding public defenders, and I've met and inherited cases from some very awful public defenders as well. We got Sharon Quidney says the real problem with the use of these sentencing charts is that they don't take into consideration the individual circumstances of the person. It also doesn't lead to any kind of rehabilitation, which is especially necessary in cases of drugs. It's really unfair. That comes over from Sharon Quidney. You're right. It is. It is unfair. It really is a gross thing that we see happen when somebody is a good person and we can't do anything for their case, or that's not true, right? The prosecutor refuses to do anything for their case because they just refer back to the sentencing charts and they just they default to that. We've seen this happen many, many times where they'll just go, well, that's the policy we have. And we say, I know that's your policy, moron. I'm telling you that this is outside of the policy. This is why it should be outside of the policy. But they just go, oh, I can't do anything about it. It's the policy. It's the statute. And you go, okay, all right. I need to talk to your supervisor or somebody who has a little bit more of an IQ. We got Ma Fox says, I'm for retroactive punishment for violent crime. Sometimes cold cases get renewed after technology advances. See, when DNA evaluation technology came out, murder cases 20 years old reopened. So I think Ma's talking about oh, okay. So he says only for violent crime. Yeah. And I think that's a pretty reasonable delineation there, Mom. I would agree that certainly technology will catch up to certain things. And we have seen that when it comes, he's talking about the statute of limitations. And so in Arizona, when I was talking about the statute of limitations for like a possession of narcotic drugs or dangerous drugs or whatever that is, it's 7 years for most felony offenses. For the other more serious offenses, so Ma, your opinion actually reflects the law, there is no statute of limitations. So for sexual assault, say in Arizona, I don't think there were any changes on this recently, but it's indefinite. Right. So 20 years later, they can do an analysis. They can come charge you with that. And it's basically for that same reason, right? There's a certain category of offenses that are so heinous that they're just going to say, well, bring it up whenever you want. We're going to go get that person because it is that dangerous to society. So I actually think that you're in alignment. The problem I have with the long statute of limitations are for those drug cases where somebody will literally change their whole life. 7 years is a long time, right? You can be an addict, a hard addict for 3 years. A year later, you're a whole different person. And so I think it's cruel to punish those people when they've made substantial progress in their lives. But unfortunately, the courts and the sentencing charts and all the guidelines and the 3 strikes, mandatory minimums, they all say that the prosecutor's hands, the government's hands, and even if the prosecutors wanted to do something, sometimes it's in the judge's hands, and the judge refers back to the sentencing charts. So it's a very frustrating situation. Pinky2 says, just my opinion, 7 years is too long. We only get a tax audit, 3 years being the norm. Drug charges should give help, but for a longer time. And when they are in rehab, they slowly pay back right away for their rehab costs by community service, an hourly pay they can earn. Repeat offenders get longer rehab. Joe, changes with the wind. Yeah, those are all great solutions there, Pinky. I mean, I think that rehab, sort of mandatory drug programs in lieu of going to custody. If you prefer to go to prison, then go and get clean, then okay, then we'll give you that option. But I think most people would benefit from treatment and rehabilitation rather than prison. And I can tell you, right, we've been practicing now for 8, our firm's been open since 2014. So 7 years. I've been practicing longer than that, but drugs are very easy to get in prison. People use them all the time. So to sort of send somebody who's a drug addict to prison where they're going to get drugs anyways is asinine. Farmer's daughter says he was talking about the black inmates. It should be the same across the board. Secondly, the psych test for cops. Does that mean not a Trump supporter or a Republican? It's a good question, right? there's a lot of questions about that right now. What does that mean? What does that entail? They're asking for social media access to a lot of the military service members. They're talking about libertarians being a threat to the government. I saw another headline today. I can't recall who said it, but basically a lot of the white supremacy problems are coming from ex-military and law enforcement, former law enforcement. Maybe that's exactly what they're looking for. We have NY, the New York Renal MD, the doctor is in the house. Elephant in the room, Joe Biden was given his questions his people saw in advance. Even so, he put forward his answers in a barely coherent stream of consciousness. Pelosi asked Pence to activate the 25th Amendment. Where is Nancy Pelosi now? As vulgar as Trump was, he could formulate a sentence and reveled in dueling with reporters and speaking. Who is running our government? Yeah, that's a doctor in the house, folks. You know, I think that this is going to be a big issue. If I can make a prediction on this show, I think at some point here in the near future, it is going to become illegal for internet purposes, okay, for YouTube, Twitter, Facebook, whatever, to comment on Joe Biden's mental capabilities. I think we're going to see a policy change. I think we're going to see context boxes. We're going to see something in the next, I would say about 2 years. Maybe between now and 2022, if I have to have a prediction, and predictions are kind of good. You know, I started reading what's it called? Star Slate Codex. And he makes a lot of predictions. And I like that. It's kind of a fun thing, right? Hold you accountable on a prediction. Maybe I'll write this down on a wall somewhere. I think within 2 years, we're going to see modifications of content policies that say you can't make those determinations anymore. If you come out and say, hey, I think Joe Biden has dementia, right? They're going to say, nope, you're not a doctor. You're making medical claims on the internet. Just like they're doing with the COVID stuff. Now they're modifying the vaccine stuff. I think they're going to make that same move with Joe Biden. You can't comment on that anymore because you're not a medical doctor. It's going to be lumped into the harassment, the bullying, something one of those categories. I've spent a lot of time going through the YouTube community guidelines lately. And I think they're going to probably fit something like that in, right? They're going to make it a problem if you are being critical of another person's physical mannerisms, physical speech, something in that category to stop these types of comments. Because Joe Biden did not look good yesterday. Not at all. Pinky number 2, Joe could change the failures of the past by letting those drug offenders out with an infamous executive order. Yeah, he signed, 56 of them so far? Sign another one. I'd support that one, right? He's responsible for the current situation. I can't think of if anybody can think of somebody who's more responsible than Joe Biden. I've been asking this question for like 6 months. I would love to know who that is. Is there anybody more responsible for the current state of our justice system than Joe Biden? Close second would be Kamala Harris, right? She was a prosecutor. She was an attorney general out of California. She made fun of a lot of people who were in prison. Please, sir, can I have some water? Please. Remember that little interview she did? So they're just 2 peas in a pod. We got Jen McClellan says, Robert Gruler, my 9-year-old, says that maybe Biden should know what jail is like before he sends people there. Shouldn't he? Funny kid. Pretty astute observation there. Jen McClellan, 9-year-old. He sent a lot of people there. I can't think of anybody else who sent anybody more than him. We got Daisy Finn O'Lee. Says, why not provide education and trade training before low-income citizens turn to crime? Not saying a free college degree, but definitely jobs and training and job skills needed in their community. I am all about that. I support that massively. Okay, I think that education now, I don't know what's so complicated about it. You can go on YouTube and learn basically anything that you want. People are giving away courses all over the internet for free. Tons of Harvard courses. Courses are everywhere on the internet. Education, I don't know what is so complicated about it right now. With these teachers unions and opening the schools and all of this stuff, I've had ideas. I think I've shared on this show previously about little, sort of community hubs that are little COVID, hotspot free and all this stuff. But yeah, I mean, more education. Highly support education. I think that more people should not give up on any of that. We got NY Renal MD says, someone who isn't a patient of mine can sue me for malpractice. Doctors do not have record erasers, even if the cases are dismissed with prejudice. Yeah, exactly right. So he's a doctor. Even physicians are curtailed. I was part of a COVID-19 Discord. They fired many of the medical experts who were answering questions and put non-medical moderators back in July. Yeah, right. Yeah, you're not going to be allowed to talk about this stuff. He was a COVID-19 Discord. And yeah, attorneys, we can get sued. We got malpractice. We got malpractice insurance all over the place. But we don't get qualified immunity. But the police do. We got Jackalai in the house, says, where exactly do we draw the line between people having screwed up in their life and the need for second chances? The biggest problem in jurisprudence, as far as I can tell, all the way back to Hammurabi's code, is when to forgive and when to forget. Do we have a better handle on defining this today? No, I think a lot of people are still very much in the retribution mindset when it comes to criminal justice. They want punishment. They want just angst. They want to grind people. And they go, she shouldn't have done that. What a horrible person, right? I hope they throw the book at him. And they just sort of consider people to be pieces of meat without any redemption that they're just going to throw through the justice system. It's really abhorrent, in my opinion. I think that people are people. Some people have difficult life circumstances. Some people are broken, but that doesn't mean that they're not humans anymore. How about we have some empathy in this system? And, this is why I'm against the death penalty. And a lot of people say, well, what if your brother was killed? Or what if your son was killed? Or your mother was killed? Wouldn't you want them dead? And I'm thinking, I certainly hope not, man. I really hope that I wouldn't just be waking up every day, basing my life around the existence of another person still being alive and just operating on it. And I can only have closure when that person is dead to make me whole. It feels like a very resentful, vitriolic, acidic way to live life, and I just wouldn't want to do that. We have Jeremy Matrita, our last one of the day, says, Jeremy Matrita, I was also a Rush baby and first heard Rush when my dad would listen to him. Yeah, I'm officially a Rush baby, no question. I've been a long-time listener. On a positive note, I found this streaming community due to not having Rush to listen to so much. He was a voice of reason, as you are as well. I will always try to find the good that comes in spite of the bad. Man, Jeremy, man, that is such an amazing comment to me. I mean, I can almost feel myself like welling up a little bit. Rush was such a big force in my life, and just even to be even thought of in that same, I will never be in the same category, but just as somebody who's also doing something that I think he was doing. He was out there speaking his mind. I think he was trying to be useful to this country. I know many people don't believe that, but I thought what he wanted to do was to share his ideas, to create a community, to, push forward a movement to make lives better in this country. That's all that I'm trying to do. And so I'm humbled that from one Rush baby to another, I'm grateful that you're here, and I appreciate the support. And that compliment, it means more than you'll ever know. So thank you for that, Jeremy. All right, so that was it for the day. I do have to wrap up. Good energy on this show. I apologize. I'm disappointed that I have to leave, but I do. Before we sign off, let me say thank you to all of our followers, all of our supporters over on Locals. You guys make it possible and keep us energized and enthused. Before I block down here, let's take a look at Seiji Takahara, which I haven't seen lately. We got Fishcat in the house. Of course, we got Chris Wiseman, who's always been just outstanding. We got Just XUXA, Shaner Wright, Chris Bean 101. We got Sabo Abbas, Tim MCD. Then we've got the Mariner in the house. We got _ Shades, Keith C3. We've got One Drop down here. We've got Drew 11, JT6058. We also got Echo House in the house. We got Power Man. We got E. Dantes. We have John M. Vice. And then we got two new people who signed up. Welcome to number one, Bumma Lickit. Bum-a Lickit. Bum-a like it? Bum-a lick it. I don't know. Then we got Gust Click. Both of you signed up and you're supporting us over on Locals, and we're grateful for you for being there. It's a great spot to be. We're building up a little bit of a community over there, and we'd invite you to go check it out. You can get some good stuff over there. Copy of my book is available for free. Of course, get the slides over there. Miss Faith posts those after the show. We have our impeachment party template, which is available. This is kind of getting a little bit stale. We're going to have to modify this soon. I got to think of what else to put in there. Then you can get a copy of our existence systems. This is my little personal productivity tool that I use. I made a video about it on January 1st if you want to take a look at that. And then we've got links in conversation. Like for example, Chris Wiseman posted a link to the Fifth Circuit Court of Appeals opinion. And I was like, how the hell did I miss that? I'm sort of in and out of the blogs all over the place, and I just missed that one. So I appreciate that. Thank you, Chris, and thank you to all of you over there who share awesome stuff. It's a lot of fun to sort of have a little community, and so I'd invite you to go on over there. All right, before we sign off, I want to remind you yet again, I'm a criminal defense attorney, if you haven't noticed, and what we do here is we help good people who've been charged with crimes find safety, clarity, hope, and in their cases and in their lives. And if you know anybody who wants to clear up a current criminal case, who wants to clear up an old criminal case, who has a mugshot on the internet, who wants to restore their rights to vote, restore their right to possess a firearm, if they just want to clear up their record in any general capacity, we can help with that. We're very good at what we do. We offer free case evaluations. All of our contact information is in the description below. So give us a call. We'll make sure that we take good care of anybody that you send our way, and they'll leave our office better than when they came in. So that's it for me, everybody. Thanks again for joining us today on this early episode. We'll be back same time, same place tomorrow. Back to the regular time, 5 p.m. Arizona, which is Mountain, 4 p.m. in California, which is Pacific. Then we've got 6 p.m. in Texas. I hope that they're hanging on there, and the other people down in Central Time. I know it's kind of a precarious situation there, but hopefully they're going to work their way through it. 6 p.m. for them. Then we've got 7 p.m. on the East Coast. Everybody, thank you so much for being here. Have a very wonderful evening. I will see you all right back here tomorrow. Bye-bye.